Mr. Kirsanow.
Good afternoon, Chairman Pierce, members of the board. I'm Peter Kirsanow, partner in the Labor Employment Practice Group of Benish Friedlander. As opposed to my previous two colleagues, I'm not the same person I was yesterday. I was Denzel Washington. I'm a very aggressive barber. I'm appearing on behalf of the National Association of Manufacturers, the preeminent industrial association in the United States, and also the largest industrial trade association, representing employers large and small in all industrial sectors in all 50 states. The tens of thousands of manufacturers have a distinct interest in the rulemaking, and we respectfully submit that the rules compress time frames for the conduct of an election would have a significant adverse impact on the meaningful exercise of employees' Section 7 rights, 8C rights, and on the workplace in general. It's arguable that more time rather than less time is necessary, and at least no less than the current median, whether that be 38 days to 42 days. As noted by members Johnson and Ms. Gamera, there are several federal statutes that outline specific time periods that are longer than the 38-day median for employees to consider matters no more consequential than those involving the selection of a collective bargaining representative. By compressing the time frame in a representation election, the proposed rules will essentially eviscerate the ability of employees to make an informed choice, an informed exercise of their Section 7 rights, and at the same time impair the 8C rights of employers to communicate effectively to their employees. And as mentioned by Member Johnson during some of the exchange earlier this morning, it will chill the robust exchange of ideas as envisioned by both Congress in enacting the act and as enunciated by the Supreme Court in several cases, not just Chamber of Commerce versus Brown, but letter carriers versus Austin, and a whole host of circuit court decisions, especially D.C. Circuit Court decisions. I don't think we should make any mistake that the cumulative effect of the proposed rules, as they have an impact on Section 8C and on the compression of the election period, reducing the median time frame between the filing of a representation petition to the conduct of the election from 38 days to, although there has been some dispute as to the number of days it may fall to, but anywhere from 10 to 20 days, will deprive employers of the ability to communicate vital information to their employees regarding their rights and the effect of unionization. Even under the current median of 38 days, it's been my experience that many employers have a difficult time effectively communicating their message. Now, that's especially true for smaller employers, as has been testified to already, but it also affects larger companies as well. Under a not atypical organizational campaign, the union may start collecting authorization cards even a year, but very often 6 to 8 months before the filing of petition. And during that time, they're communicating their message to the employees with very few legal constraints or practical constraints. Not all employees are necessarily going to hear the message, and I would challenge the proposition that most employers are aware of it, of the campaign from the very beginning, because there is very often the case that employers are completely oblivious to the fact that an organizational campaign is underway. The employee population, or at least portions thereof, is hearing an unrebutted, sometimes one-sided story, frequently an inaccurate one. They may not hear of all the downsides of unionization. They may not hear about dues, fees, and assessments. They may not hear about some of the union's political postures or social agenda with which employees may disagree. They may not hear about the prospects of unionized companies, some of which are faltering, some of which go out of business. And the union controls the filing of the petition, which also controls the approximate time of the election. This may be the first time that many employers first hear about an organizational campaign. And it's also the first time many employees are aware that there's a campaign underway. And the election date's a mere 5.5 weeks away under current circumstances. It takes many, if not most employers, even some of the larger ones, at least 2 weeks to figure out what they need or want to say regarding employee rights and unionization. And then they have 3 to 4 weeks under the current time frame to communicate that message to the employees, in contrast to the 30 to 40 weeks sometimes that the unions have been conveying their message to the employees. Logistics can be even more challenging for the employers who don't have all their employees in a centralized workplace. Where the proposed rules implemented, in very number of cases, employers may not even have figured out what they want to say by the time the election is conducted. That would essentially deprive employers or impair employer 8C rights and make Section 7 rights a fiction. The compressed time frame is enormously beneficial to unions. Indeed, for those of us who've been involved in hundreds of election campaigns over the years, it's difficult for us to conceive of a situation in which a union couldn't organize a workplace or successfully win an election, especially given the impact of specialty health care. But I would submit that the compressed time frame is profoundly harmful to the interests of employees, many of whom would be making an uninformed choice about one of the most important aspects of their lives, and also profoundly harmful to the interests of employers who would in many cases be effectively removed from the decision to unionize their workforce and provide very little input into that decision. And for those reasons, the National Association of Manufacturers would respectfully submit that the rules, at least in terms of their compression of the time frame, issuance of such rules be quashed. Thank you.
When you talked about the employer getting its message out, you said it takes it how long to get the message out?
Under the current time frame, and we've heard a lot of anecdotal information, and that's why I think it might be beneficial to see if more information could be adduced, more empirical information could be adduced along these lines. But I've been doing this for 35 years despite my incredible, robust, and vigorous appearance. My compilation of anecdotes says that, especially among the smaller employers, you're looking at least 2 weeks. What is happening is, and this I'll give you something that happens maybe on a biweekly basis. Get the phone call. Denzel, I understand that one of my factory workers has been talking about a union. I said, you should be aware that you're probably going to get a request for recognition or a petition imminently. Now, my employees are not really interested in unionizing. True story, I got one of those phone calls at about 9:45 in the morning. By noon, he calls me back saying, I got the petition. From that period of time, a lot of smaller employers who don't have a standing HR department, don't have a retention agreement with the Labor Council, are scouring around, maybe talking to their wills and trust attorney to try to find out who it is they should need to get in touch with to help them with respect to representation campaign. They will sit down with their attorney, try to figure out what it is in terms of union placement is going on, what they should be doing in terms of possibly stipulating, or maybe going to hearing. There are a number of determinations going on at that time. And keep in mind, most companies, strangely enough, are not in the business of conducting union elections. They're in the business of making widgets. And that same person who's making those determinations with respect to unit placement, stipulation, is the same guy who is repairing tow motors, signing bills of lading, dealing with a whole host of issues. He was wearing multiple hats. So up to 2 weeks could go by before he determines what his position is going to be, before he even knows that he wants to send out campaign materials, maybe have some elections. Now, that's not the case for T-Mobile or some companies that have standing HR departments, but I have the good fortune of representing some larger companies, and they have some of the same issues as well.
None of that was my question, but thank you for your comment. My question was, you said there was a certain period of time, 2 weeks, to decide on what they were going to campaign, and then a certain amount of time to get the message out. All I was really asking for was that time period to get the message out, sure. What you said.
3 to 4 weeks.
3 to 4 weeks to communicate with their employees would take 3 to 4 weeks to communicate with them. And so when you're talking about the employer's message, is that the same, does that equal to the information that you believe employees should have and might not have if the employer doesn't have that 2 to 4 weeks?
That 2 to 4 weeks in which to communicate their message is after they've already, to some extent, decided what that message is going to be.
But what I'm asking you is the employer's message, which you referred to many times, the same thing as the information you believe employees need, which you also referenced. And I wondered if you were using those terms interchangeably.
Yeah, I think they're to some extent coextensive, but not completely.
Okay. So the information the employees need is the information the employer wants them to have.
Not necessarily, no. The employer may not be giving them all the information employees need. So we have three parties involved here, a union, employees, and I think you had a very eloquent witness earlier on that talked about the fact that to a large extent, much of what we're discussing here seems to be not in the context of what's best for employees. And you have the union. So employers may be giving them what they believe the employees need. Employees, some of them are gathering some of the information they believe they need. The unions are giving them the information they think they need. Hopefully, all of those circles will be, to some extent, coextensive, and the employees will get all the information they need.
Former member Kirsanow, getting to the, and again, I don't mean to discount the importance of the interests of employees or unions, but again, focusing on the interests of employees. You know, our statute adopts a majority rule concept, and I guess the question that I have is, how much do we have to care if we have an election which ascertains that a majority of unit employees at that point in time have support for the union? How much is it our province to care that much about whether the remaining employees participate in election discussions or actually have an understanding about the relevant issues once you get beyond the point of majority rule?
I think Section 7 presumes that the board care, that all employees have at least some meaningful opportunity to participate in the process. And in any election, whether it's a board election or whether it's a national election, some people may choose not to participate for whatever reason.
As you would know, having been a former board member, the process, the election process from petition to actual election has, over the course of years, been reduced. It's been 56 down to 42, down to 38. Is it your position that as that process gets smaller, the First Amendment rights of the parties are being infringed, particularly the employer? And if so, it's our responsibility as the board to expand that process out because we're denying them their rights under the First Amendment?
I do think that there's a point, an irreducible point beyond which, if the period is compressed, that First Amendment rights would be infringed upon, mainly from a logistical standpoint. I think that it's difficult to effectively communicate, whether it's the union, whether it's co-workers, or the employer, positions with respect to unionization or information related to the effect of unionization in a compressed time frame, depending upon the nature of the employer.
And what would be that irreducible point?
Difficult to ascertain. I do think that right now we're at a 38-day median. I think if you polled, I think if we conducted, I think we're in an informational vacuum. I think there's a good chance that we might get a better idea if we had more information related to the positions of labor organizations, employers, and most importantly, employees as to what it would be. But the experience that many of us have had is that the current 38-day minimum, in fact, may not be enough time to get that information out.
Mr. Washington, I enjoyed you in the hurricane.
I was pretty good in that.
One quick question, not related to your many movie roles. Basically, if we had to search out to another statute to find, if we wanted to tether something to a congressional enactment or a legislative history, like JFK's comment on the 30 days, the ADEA on the 45-day group, for example, separation agreement evaluation, the 21-day for the individual, the 60 days in the WARN Act, some other yardstick, which one would be appropriate?
I wouldn't take a position as to that, and I don't mean to be evasive, but I think each of those is a imperfect measure because we're talking about different things. With respect to WARN, for example, employees are about to lose their jobs. They need to make provision. The State Employment Relations or State Employment Agency needs that information as well as the union also. With respect to the OWBPA, another thing. They're about to lose their job. They have to make a determination as to whether or not they're going to accept certain benefits. So it may be 21 or in the case of a number of people, 45. Here, the employees are keeping their jobs. It's something that's going to be a long-term, hopefully, endeavor. If they are unionized, they may be unionized for the next 30 years. It's something that could have even greater consequence than the determination as to whether or not to sign a release under the OWBPA. But I think at least those are benchmarks, and it should be informative that Congress has chosen longer periods for those terminal circumstances than in the ongoing circumstance of a representation election.
Well, wouldn't you say it's informative in the Agricultural Labor Relations Board where they have 7 days to have an election?
And I would submit that that's a very discrete sector of the industry, and I think what needs to be done is what Congress did with OWBPA, that applies to all employers and all employees regardless of occupation or industry. The board, in large measure, is more charged with that circumstance